This is a key piece here because I want folks to see this case as I'm now starting to see it. Post this ruling and even before is because this isn't just about Tornado Cash. It's far broader than that. It's not even just about privacy. It is that, but it's also far broader than that. What you just said is, did Roman Storm have control over an immutable smart contract is pretty key because everything that we are building in DeFi is an immutable smart contract. At least the purely decentralized things are. So you think of like the Uniswap protocol, right? It's a non-custodial smart contract that has some funds inside of it, but is outside of the bounds of the developers of the Uniswap protocol, right? It's immutable, it's on chain. They don't control it. They can't access it. They cannot moderate who puts funds inside of the Uniswap protocol. And that's been true of Uniswap v1 all the way to v4 today. So this is broader than just privacy. It's certainly broader than just Tornado Cash. This is about all of decentralized finance, isn't it? Because a lot of this hinges upon this idea of, did Roman Storm, was he responsible for the non-custodial smart contract deployment, essentially a DeFi protocol that he published on the Ethereum blockchain? Is that about right? Or what have I gotten wrong in that description?
I think you're absolutely right. And maybe a few thoughts about this. One is this really strikes to the heart of what we are trying to do in DeFi. The purpose of DeFi is to create decentralized systems that do not rely on trusting a single centralized third party in order to operate or in order for users to get access to them. The second that you reintroduce a centralized intermediary with control over a smart contract in a traditional Web 2 finance kind of way, then you're not doing DeFi anymore, at least in my opinion, right? You're losing all the benefits of resilience and transparency and trustlessness and permissionlessness that is at the heart of what we are trying to build in this industry. And if you go all the way back to 2013, so let's go back in time to sort of the beginning of the analysis of this particular regulatory issue, the Financial Crimes Enforcement Network, which is a bureau of the Treasury Department that enforces the anti-money laundering laws, recognized that this nature of a public blockchain, its decentralization and its permissionlessness, was in tension with the Bank Secrecy Act, which essentially says if you are a financial institution and you're processing transactions on behalf of customers, then you have some anti-money laundering compliance obligations. You need to monitor those transactions. You need to do KYC, know your customer, identify who all your customers are. You need to identify suspicious activity. You need to report that to the government. You need to have internal controls to make sure that you as a company are following all of those rules and a number of other types of compliance obligations. Now, in the context of a decentralized smart contract protocol, there is no way to identify the users of the protocol. There is no financial institution that can comply with those obligations. But in the very early days, when folks were still wrapping their mind around what is a blockchain-based business, there were questions about whether a centralized exchange should be treated like a financial institution under the Bank Secrecy Act. And thankfully, FinCEN was maybe the only agency at any point in time to give clear guidance about when compliance with the Bank Secrecy Act was necessary. And they explained if you have control over user funds, if you are a money transmitter under their regulations, meaning you accept funds from one party and transmit funds to another party or another location, well, you're a money transmitter and you have to comply with all those regulations. And over the course of years, from 2013 all the way up to 2019, FinCEN continued to give guidance about when actors in the crypto industry were or were not money transmitters under their regulations. This all came to fruition in 2019 guidance that summed up FinCEN's entire view on this issue. And the 2019 guidance is probably the most referenced regulatory guidance of anything in crypto. It's something that all of us for the last 5 years in DeFi have looked to understand. Do we need to KYC users of this system or not? And in my view, the 2019 guidance makes very clear that an immutable smart contract protocol is not a money transmitter transmitter, or rather the developers of that protocol are not money transmitters by virtue of developing the protocol and do not need to register with FinCEN. Nonetheless, here comes the Department of Justice in this criminal prosecution. And their argument is, we are not bound by Treasury's guidance. You all in the industry may feel like you've been following what they told you to do for the last 5 years. That may
Wow.
satisfy them, but not us. And even if you are not in violation of the Bank Secrecy Act, nonetheless, you may be violating the criminal law and you may have to go to prison for it. So that's what's happening in this case.
So that's essentially what they're saying about Tornado Cash, and that's why the stakes are so much wider. The stakes are potentially all of DeFi in the United States. So can you get us to the like and just to clarify my understanding of this, Jake, is like in the ruling, maybe we'll get to the ruling that happened on that Friday in September. In the ruling, the judge, by saying that Roman Storm had responsibility, that Tornado Cash and his development of Tornado Cash was essentially a money transmitter, right? Then de facto, is she not implying that all DeFi protocols, potentially smart contracts, could be money transmitters? Or like, was this just tied to privacy? Anyway, let's get to the actual ruling and what the implications might be. So what happened in the ruling on the 26th?
Yeah, so as I said, in the motion to dismiss the indictments, there were many arguments, but the crux of the argument was Roman Storm was not operating an unregistered money transmitting business because what he was doing, offering a website, offering a user interface, writing the original code, working on the relayer network, that is not money transmission because he was not accepting funds and then transmitting funds on behalf of any other person. He never had custody over user funds. He did not have control over the protocol. And the judge basically said, that is not my interpretation of the law. My
Wow.
view of the law is a person does not need to have control over user funds or custody over those funds in order to engage in money transmission. And it's very important to note, first of all, that motions to dismiss indictments are very rarely granted. So in a sense, it's not surprising that Storm lost the motion. The standard is extremely difficult to meet. Courts are very deferential to the government. They basically say, well, as long as the indictment sort of hints that there was a crime, as long as the language of the statute that alleges an offense is somewhere in the indictment, then more or less this can go to trial. But Judge Fela went way beyond just saying this indictment is at least sufficient to move on to trial. She actually made a holding on the core legal issue that control is not necessary to engage in money transmission. And she sort of steps back and does what I think is a bit of a sleight of hand that the government does as well, which is to describe Tornado Cash as a whole as a service. So she says that Roman Storm was offering a service that was the Tornado Cash protocol, but she doesn't engage at all with the details about what that service actually might be. And I think we could all agree that, Storm was offering some type of service. There was a business here. There were ways in which he was being compensated for that business, but the business was not the business of money transmission. And that's something that Judge Fela, at least in my opinion, just didn't engage with in the ruling.
Okay, so can we talk about this term money transmission? Because we're talking a lot about this. This court hinges upon the judge's definition of like what money transmission actually is and who's a money transmitter and who's not. We'll talk more about that. But like, why is that even important? So say I'm a money transmitter, Jake. Does this imply some level of responsibility, like culpability, a set of things I have to do? Why is money transmission so important here?
Yeah, so it's a great question. And this might get a little bit in the weeds of the law, but hopefully the listeners will appreciate understanding a bit more how these different statutes play together. Exactly to your point, if you are a money transmitter, then you are a type of regulated financial institution under the Bank Secrecy Act, which is that law that the Treasury Department, FinCEN, enforces. As a money transmitter, you have to go register with FinCEN. You have to KYC all of your customers or users. You need internal controls. rules. You need to designate a compliance officer. You need to do all kinds of reporting and record keeping under the Bank Secrecy Act. So being a money transmitter imposes a lot of compliance obligations on you under Title 31 of the US Code, which is where the Bank Secrecy Act is. Totally separately from that, you also could be subject to criminal liability under Title 18 of the US Code. That's where all the criminal laws are that the Department of Justice enforces. And Title 18 makes it a crime, specifically under Section 1960, to operate an unregistered money transmitting business. So the way that ordinarily we would think about this before the Department of Justice recently took a different position is, if you're a money transmitter, but you don't register with FinCEN, you've committed two separate violations. Number one, a civil violation under Title 31 of the Bank Secrecy Act. The Treasury Department might enforce that violation against you. And number two, a criminal violation under Section 1960 of Title 18. Then the Department of Justice might come and prosecute you criminally. But we all assumed that this was all or nothing, right? You've either complied with the law or you've not complied with the law and violated both of those different statutes. Here, the Department of Justice is saying that's wrong. You can be in compliance with Title 31, following all of Treasury's guidance, and nonetheless be engaged in money transmission as we differently define it under Section 1960. And that, frankly, breaks my brain. I don't know how an industry could possibly operate when we can't follow the guidance of the Treasury Department, which is tasked with enforcing this type of statute.
So you said is it Title 18?
Title 18 is the criminal code, yes.
That's the criminal code, and this is what Roman Storm was explicitly charged with, among other things, a violation of Title 18. You said that is a criminal charge. So when we talk about criminal charges, right? So I mean, we're talking about what, like jail time? Like, what are the penalties for this type of a criminal charge?
Yeah, the potential penalty for operating an unregistered money transmitting business under 18 USC Section 1960 is 5 years in prison. And, he's also accused of violating Section 1956, which is the money laundering statute. You could tack on more years for that. And then there's also the sanctions violation, which, again, all hinges on essentially the same general allegation that Storm is liable for third-party misconduct that he could not control at the time that it took place.
And so these charges stack too, right, Jake?
It depends on sentencing. Often if there is a conviction for more than one charge, the sentences end up running concurrently. So you could get 3 5-year sentences, but you don't serve 15 years. You serve the 5 minus some for good behavior. This is all stuff that gets worked out in sentencing. But we are talking about the liberty of a software developer. This isn't just a question of whether there could be a fine for a company or whether the business can continue operating. This is, in my view, for the first time, the United States government saying the developer of an open source immutable smart contract protocol should go to prison for how someone else abused that protocol, even though there was nothing he could do to stop it.
To continue leveling up your crypto game, then you need to get on the Bankless newsletter. It's the world's most popular crypto email and is completely free. Just click below to sign up.